Good morning, everybody. This is Viridis versus Michigan Marijuana Regulatory Agency, case number 21-000219, continuation of the evidentiary hearing on the request for a preliminary injunction. I received plaintiff's motion for leave to file supplemental brief. I assume the AG's got copies of it. I'm going to grant the motion. You can respond if you want, but it's law that I think we're all probably pretty aware of. But it's up to you. I don't know if you have you looked at it. Okay, I don't need a response, but if you I don't know if you want to do it just to, you know, dot all your I's. Cross.
Your Honor, I don't have a response to what it is.
Yeah, okay, good.
Okay.
All right. We are, I think what we were gonna do is call a witness from defendants, right?
Yes, and she'll be appearing to be sued.
Oh, she will, okay, all right. And who is this?
It's Claire Patterson.
Okay. Yes,
I want to make an objection. It appeared yesterday. We offered areas that this witness was expected to provide testimony on. All sounded to us like they were all post hoc rationalizations. If she did not demonstrate that they were communicated to the licensee before the recall, there was nothing that she could say now to try to shore up the basis for the recall that was never communicated to the licensee.
well, you want to respond?
Your Honor, we didn't proffer any proposed line of testimony from Ms. Patterson to begin with. And calls are a matter of emergency, and there is no.
If she can establish that these are, whatever she testifies to was something that they internally discussed before the issuance of the recall, that's not a post hoc. They just didn't tell your client about it, right? I mean, and then that's comes to the veracity of the testimony. You know,
We'll see how it
yeah.
but I want to put that on record ahead of time.
Okay.
Like some of those areas were.
All right. Yep. Thank you. All right. So can we get Ms. Patterson up on the screen, please, Jeff? Good morning.
Good morning, Your Honor.
You are Claire Patterson?
Yes,
Okay, and you can hear me fine?
I can.
All right, would you, I'm gonna swear you in before your testimony starts, okay?
Sure.
So would you raise your right hand? Do you solemnly swear and affirm that the testimony you will provide in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you.
Will you please spell your name, or excuse me, state your name and spell both your first and last name?
Yep. My name is Claire Patterson, CLAIRE PATTERSON.
And where do you work?
I work for the Marijuana Regulatory Agency.
In what capacity?
I am the Scientific and Legal Section Manager.
How long have you worked at the MRA?
Almost 3 years.
And how long have you been the manager of that section?
Let's see, a year and a half now, approximately.
Okay, and before you were the manager of that section, what did you do there?
I was a laboratory scientist specialist.
Okay, and can you just give us a very brief rundown of your educational background? But please try to speak fairly slowly because there's a court reporter here trying to.
I don't know why that feedback's happening. I heard it yesterday too, but stop it, so.
Please try to speak fairly slowly because we have a court reporter trying to take down your information.
Sure. I received my master's degree from Michigan State University in plant biology and plant pathology. Do you want me to continue from my educational to my experience?
Well, what year did you graduate with your master's?
2015.
Okay. And can you give us a breakdown of your professional background?
Sure. I've been working in the cannabis industry since 2014, either directly or adjacently in a regulatory capacity. I have served as an independent consultant for ISO accreditation. And as I've said, I've been with the MRA for the better part of 3 years now. Additionally, I am a co-chair for the National Cannabis Regulators Association for the Lab Testing and Standardization Group. I am an expert reviewer for the AOAC microbial review panel for methods that are submitted as a part of the Cannabis Analytical Sciences program. And I serve on the AOAC Proficiency Testing Advisory Task Force for the Cannabis Analytical Sciences program as well.
And in your section at the MRA, are there other scientists?
There are, yes.
How many?
3.
Could you just tell us who they are?
Yes, I have Dr. Allison Cheerio, Dr. Noah Rosenzweig, and Dr. Patrice Fields.
Could you spell everyone's names just for the record?
Allison Cheerio is ALLYSONCHIRIO. Noah Rosenzweig is NOAHROSENSZWEIG. And Patrice Fields is PATRICEFIELDS.
And those 3 individuals all hold doctoral degrees?
Yes, they do.
Okay. And so obviously we're here on a matter filed by Viridis, partially in relation to a recall. Are you familiar with the recall circumstances?
Yes, I am.
Can I just start out about the recall? Product that was placed under recall, what can consumers or licensees, what can they do with if they have that product? Can you just kind of inform the court what's going on with that?
Sure. So if consumers have that product and it's not been used, I believe that they have been recommended to get rid of that product. I know that some individuals have opted to return that to the place of purchase, but that's largely dependent on what those retailers are doing in terms of take back. Now, as it comes to the growers, the licensees who are a part of this, they are able to have their product resampled and retested. If the products are retested and they pass for a microbial panel, then those products are available for sale. If those products, however, fail, then we would recommend that they be remediated in some capacity. And then those would need to be retested after remediation again as well.
Are you able to tell us where in the process, like how much of the product has been recalled or retested?
So I'm not entirely sure the total percentage of what has been retested. I know that a total number of source packages tested is 829, but each of those source packages may relate to a lot of smaller, what we call child packages or derived packages.
And have you received any results whether any product is passing or failing?
Yes, I have.
Can you tell us that?
Yes, as of this morning, December 2nd, I believe, we have a total percentage passing at 73% and a total percentage failing at 27%.
And failing for what? What's showing up in the product?
So those samples are failing for either total coliforms, total yeast and mold, or aspergillus. Fortunately, we have had no failures for E. coli or salmonella.
Okay. And those three are microbials?
Yes.
And
It was mold and aspergillus and what else?
Coliforms.
Coliforms?
Yeah, those are a type of bacterium.
And has the MRA been made aware of any adverse reactions from any consumers or licensees who are aware of that?
Yes, ma'am.
Can you tell us about that?
We have received 18 adverse reaction complaints since the issuance of this recall. In looking at those, they range from pretty serious side effects and hospitalization to more mild allergic type reactions.
At this point, are they still just
Hold on a
reports?
second,
Oh.
yes?
Your Honor, we object to that. She's talking about notices they received after the recall. Again, the post hoc rationalization.
Well, I don't know if she's offering that as a rationalization for doing it. It's just an explanation of what occurred after the fact. Unless I'm wrong, and then if that's what she's offering it for, then you'd be right.
May I proceed? Right now, they're just reports. They haven't been yet investigated.
That is correct. They are in the process of investigation right now.
There were audits on October 26th and 27th of this year at each lab location, correct?
That is correct.
And can you tell us what led up to why you were doing the on-site audits?
Well, the on-site audits were part of a series of ongoing investigations, but specifically as it relates to this recall, we had started noticing in Metric, which is our statewide monitoring system, that packages were failing for aspergillus and then being sent the next day to the laboratories, at which point they were being reported as passing without remediation by the grower.
Let me back up. Packages were failing from other safety compliance facilities,
Yes,
and then they were sent to Viridis locations?
correct.
Okay. And then, so just I wanted to make the record clear. And then,
Well, I'm sorry.
oh, I'm sorry.
It's still not clear to me.
Okay, can you
What-
explain can you
yeah.
explain in very layman's terms what it means? Packages were failing, packages were sent to,
Of course.
Well, let me ask you, I mean, my understanding is that the growers send the plants, a batch of the plants to Viridis and the other labs, and then they do the testing, and then they input the results into the Merck or whatever it's called, the system. And then if it's an approval, then the growers do whatever they do with the plants. So how does this all fit into that?
That's a great question. So typically what will happen is because metric, our monitoring system, is the way it is, a lot of these packages get what we call locked up in the system. So they get set to a status that has to be updated manually by us at the MRA. And those update requests come to my team, the laboratory scientist specialists, for updating. And so initially, these packages were tested at other laboratories, and they were reported as having failed for Aspergillus. Now, if something fails as part of the administrative rules, they have to then pass 2 subsequent retests. So these growers were then sending the samples to Viridis Laboratories or Viridis North, and then they were passing those samples subsequently without remediation.
Okay, so Viridis in that circumstance was it was not product that they were provided, it was product provided by the MRA as a retesting to verify what the other labs were finding.
Nope, so that product was still submitted to the lab by the grower directly. We don't physically touch any of those samples.
Okay, so a grower submits a sample to a safety compliance facility or a lab.
Mhm.
And if there is a failure, what is the grower's option then?
So if there is a failure, I would expect that they would remediate that product in some capacity.
What's that mean?
So to remediate a product, a lot of times what growers will do, especially in the case of mold, is they'll subject it to some sort of like a UV treatment or an ozone treatment to kill the mold that is present on the sample. Additionally, they may turn it into concentrate, but in this case, that's not relevant.
Okay, and so if there's remediation and they're required to then have it retested?
Yes, that is correct.
Okay, and that is at a different safety compliance facility?
Nope, it may be at the same safety compliance facility.
Okay. Okay, so just to clarify, you and your team were seeing that other labs had failures for Aspergillus. They were submitted, these samples were submitted to Viridis for retesting and showing passes.
That is correct.
And was there a trend whether the product was being remediated or not before Viridis was doing the retests?
Yes, my team reported to me they'd noticed, several samples that had been sent the next day. And it was reported by the grower that they had not been remediated.
And so what happened after that? What did you do upon that information?
So upon receiving that information, it's unusual that something would pass under those circumstances. And so we began requesting additional information from the laboratories through Metric, as is our procedure.
And so then what else happened after that?
So one of the things that we had requested were temperature monitoring logs, as well as time monitoring for the incubation of those samples, which is a fairly easy thing to submit via e-document. Then additionally, we obviously went on site for the on-site audit.
Did you request time and temperature logs from both locations?
Yes.
And what were you provided?
We were provided temperature logs only, I believe, from Lansing.
Okay. And as far as microbial testing, is it of what importance is it to be able to monitor and verify time and temperatures?
So methods themselves are validated to a specific time and temperature range. These methods undergo a very rigorous validation set up by the manufacturer and then verified by the AOAC in this case. And any deviation from those time and temperature parameters can lead to inaccurate or unreliable results ultimately.
Okay, so did you review the temperature logs that was provided from the Lansing location?
Yes,
Did you make any observations?
yes, there were deviations. There were deviations in the temperature log for total yeast and mold testing specifically that deviated from the manufacturer specifications and the specifications on the SOPs that were approved for the laboratory.
Maybe we request a spot, a sidebar. This is completely outside the scope of what they agreed.
I guess, sure. I mean, why don't we go back? All right, you can continue.
I think before we took a break, we were talking about the importance of keeping temperature and time logs. Is that correct?
I believe so, yes.
Well, actually, so you were talking about any deviations in temperature, and you talked about looking at logs for total yeast and mold.
Mhm.
Could you just give it an example of what does that mean? How long a sample needs to be in an incubator? Can you just kind of tell us about layman's terms as much as you can?
Yeah, so time and temperature, especially for microbials, are incredibly important to both promote the growth of the target organism that we're looking at and also inhibit the growth of any non-target organisms. So these vendors, what they will do is, they set up a series of parameters under which they test their methods. And then, where there is empirical data and statistical support, that's where they outline the appropriate temperature and time range for incubation of these samples, that optimal range, so to speak. And so these time and temperature ranges can be, 16 to 24 hours. They may be over the course of, 25 plus or minus 1 degree Celsius. Typically, the temperature ranges are a lot more narrow than the time ranges. But even the time ranges themselves typically don't span past 6 hours.
And those come directly from the manufacturer?
That is
Those
correct.
Specifications? Okay. And is it part of a licensee's approved SOP that they must remain within the manufacturer's specifications?
Well, so they must follow a validated method. Because the vendor validated the method as it is written, then it would be expected that the licensee follow the method as it is written and prescribed and validated by the vendor.
Okay. And if a sample incubates for a shorter time or a longer time than the recommended recommendation from the vendor, or in a different temperature range, what can that mean?
Ultimately, that would give us unreliable results. We can't be certain whether they are accurate or not.
And the temperature logs that you received from the Lansing location, what period of time did that cover?
What period of time did that cover?
Yes, yes.
From August 10th, I believe, until the date of the request at the time, which I can't remember exactly what that date was.
Okay. And other than total yeast and mold deviations for temperature, were there any other tests that were deviated from temperature wise?
Salmonella.
And did you speak to Michelle Glenn about why there weren't temperature logs from the Bay location?
Can you put a time period on that?
What if she spoke?
Yeah, when
Did
she
you ever
spoke
speak
to
with
her.
Ms. Glenn about did you ever speak with Ms. Glenn about, or Dr. Glenn about the absence of logs from Bay?
So I believe that either I or Dr. Allison Cheerio spoke with her when we were on site doing the audit on October 27th at the Lansing Bay City location.
And did Dr. Glenn give an explanation as to why there were no temperature logs from the Bay location?
So at that time, I actually don't think it was Dr. Glenn that offered the information, but Michael Lafwemba, who is the, I believe, laboratory director up there, noted that they had not been keeping them from July to September, but they had recently instituted the logs when we were on site.
Okay. Yeah, neither location were keeping time logs, is that correct?
That is correct.
And is that concerning?
Yes.
Can you tell us why?
But and can you tell us if it was required for them to do that?
So that's a great question. While it's not something that is specifically spelled out that they must keep a log, it's important to meet those time parameters that are specified by the manufacturer.
Yeah, but here's a question I have, because we had testimony yesterday and plenty of exhibits and all the rest, and it seems to me, and correct me if I'm wrong, is that these two labs had already been approved, their methods and standing operating procedures and all had been approved by the MRA prior to the recall, and as well as accredited by A2LA or whatever it's called, the ISO or and so to me, an objective viewer of this, the fact that a entity does not have a log that's not required and wasn't part of presumably their methods and SOPs, how can you hold that against them?
So ultimately, the concern is that they should be keeping a monitor on those environmental conditions, Your Honor. So the ISO, I believe it's section 6.3 on environmental conditions, generally implies the necessity for a laboratory to keep these records of environmental conditions to ensure the integrity of the test that they're running. And in section 6.3.3, the ISO formulation states that the laboratory shall monitor, control, and report environmental conditions in accordance with the relevant specifications, methods, or procedures that may influence the validity of their test results. So while it's not necessarily spelled out in rule, I do believe that it is ascribed by their ISO accreditation.
Well, yeah, okay, I understand that, but if it was so important to the safety of the testing process, wouldn't the MRA or A2LA made sure that these logs were part of in writing, the requirement be in writing in the standing operating procedures before they're approved and accredited?
So I will say from the MRA perspective, it's something that is honestly so basic that we would assume that's something that the laboratory was doing, be it either written or kept in some sort of a digital format, which can also happen. And then in terms of A2LA, they did note a deviation for the Lansing North location for not keeping logs of the temperature. But I do personally find it a little bit concerning that they didn't notify the licensee of the absence of these logs.
But the absence of the logs wouldn't result, that alone wouldn't result in a recall, correct?
I can't speak to that, as the decision to do a recall is ultimately something that is up to the directors. But as a scientist, I think the absence of proof that they're following the validated method does warrant a recall.
So she wasn't a part of the decision-making process for this?
I think she was part of it, but not the ultimate decision maker.
Correct.
So when you're in this particular case, you started looking into this more deeply because of this other labs failing aspergillus, going the next day to Viridis, and they were a fail and then a pass, correct? That's why you started kind of investigating. And so
Hey, Ms. Patterson, you have to say yes or no so that the court reporter can put down your answer.
Oh, yes, I said correct. I'm sorry.
and so you were investigating the accuracy of results at that time, essentially.
That is correct.
Okay. And so when you as a auditor know whether Viridis had a sample in an incubator for 2 minutes versus 10 days?
You would look at a log of some sort.
Okay, and we know there were no time logs kept, correct?
Correct.
And did Viridis offer to allow you to watch video surveillance of their testing procedure to verify that they were keeping the samples and incubators at the specified times?
They did offer that.
And did you take them up on that offer?
We did not take them up on that offer
And why is that?
because there's no way to link what was actually going into the incubators at those times back to the sample batches or the samples themselves. So there was no way to be certain what was actually being incubated.
Okay. That, so in addition to the concerns about the lack of logs, did you send out or have samples that were retested by Viridis, retested elsewhere?
Yes.
Can you tell us about that?
So after the samples were retested by Viridis, they had received passing results. We'd started collecting a list via metric of metric tags of these samples in question. And we sent those samples out to 5 other laboratories that are running the same method that Viridis is running for their tests for microbials.
How were the samples selected that were to be retested?
They were selected randomly from the list that we'd received from Metric.
And all of them came from the Lansing location, correct?
They did, that is correct.
Was that a pure random by chance?
Yes.
And the retesting by the other labs, what were the results of those?
So of the total of 8 samples that had previously failed, they were all reported as failures. So there was basically, how should I break this down? There are 2 retests required. And so that's a total of 8 samples broken down by 4 labs. I believe 6 of the 8 failed, but ultimately the status and metric for all 4 of those would have been package failed because at least 1 of the tests failed and 2 are required for a passing retest result.
The having other labs do these retests, was there the MRA doesn't have its own lab that does this kind of work, correct?
Unfortunately, no.
Was there any other way to have this retesting done?
No.
After you completed your audits, did you and your team complete audit reports with corrective plans?
Yes.
Were those provided to the licensees?
Yes.
And were there discussions about your findings and what was required to become back into compliance?
Yes. So on site, October 27th at the Viridis North location, we discussed the audit findings and some, I believe, very preliminary ways that those issues could be remediated with all of the laboratory management staff that was there, as well as Dr. Glenn, Greg Michaud, Todd Welch, and Kevin Blair.
After that, were there further discussions about your findings and correction steps?
Yes.
At any point, were your findings of the temperature deviations relayed to the licensees?
Yes.
And discussions about the concern of lack of time logs?
Yes.
What was Ms. Patterson, who made the decision to issue the recall?
It was a team decision, but I think it was ultimately executive.
Who's that?
Desmond Mitchell and
Who?
Desmond Mitchell, he's the field or the operations director. And
Ms. Patterson, do you know who made the decision to issue the recall?
I believe the decision was made by the director's operations director, Mr. Mitchell, and then my direct director, Julie Kleitman.
Who?
Julie Kleitman. She's the enforcement division director of the MRA.
And were you in those meetings when they made the decision? As well?
No,
assuming it
not-
was a meeting, but-
We were in meetings together where we discussed the recall, yes. I don't know that I was in the meeting where the final decision was made.
Okay, and did you ever see a document that was an articulation by the agency as a basis for the recall?
No, not a document specifically.
But had there been discussions with your team and the licensees that you were planning on recalling the product?
Yes,
And was a draft of the recall bulletin provided to the licensees to review and provide input?
yes, it was.
And did they do that?
Yes, they did.
When was that? When was, you're saying a draft of the recall bulletin was sent to the plaintiffs?
Correct.
When, do you know when that was?
I do not recall the exact date. I'm sorry.
But they did respond with, well, when it was sent to them, did you send it to them?
I believe Mr. Mitchell sent it to them.
Right.
Just generally, when testing is occurring for microbials, what's the like the average normal failure rate?
Well, so that kind of changes depending on the time of year. I mean, typically around this time of year, because it's autumn, we start to see the outdoor harvest starting to come down. You know, you can see anywhere from 10 to 25% failures for something like total yeast and mold or aspergillus.
Just for the court's clarification, can you articulate why this product was recalled and why it was for that time period?
So the reason the product was recalled is because there was no certainty that the laboratory was following their validated methods. And we did have proof in some cases that they were clearly deviating from their validated approved methods.
Why was the decision to recall this product and from August 10th to November 16th?
I apologize. Yes, because August 10th was the first date that we had received temperature monitoring logs from them, and that was the date of implementation of these methods as well.
It was the first date of the implementation of a new method.
I believe that is the case. It may have been just slightly before that, Your Honor.
Your Honor, with the deviations, was that cause safety concerns?
Yes, uncertain results could result in safety concerns.
Like how?
Because if there is product that is labeled as passing and it's available for sale to consumers, but it actually contains mold or aspergillus, that could make consumers ill.
No other questions right now, Your Honor. Thank you.
Okay. All right, Ms. Patterson, now the plaintiff's lawyers have a chance to cross-examine you, okay?
Certainly.
Good morning, Ms. Patterson. I'm Dave Russell. We heard a lot of new allegations against Viridis today, so I want to kind of walk through those. One of the things you just testified to was, I believe, and tell me if I'm wrong about this, but that the recall was issued because the laboratories were not following their validated approved methods. Is that correct?
From the scientific perspective, yes.
But from a perspective of their approved SOPs, the two laboratories never deviated from their SOPs, correct?
That is incorrect.
There's nothing in the SOP that requires an incubation log for the time in and the time out of an aspergillus sample, correct?
That is correct.
And I believe you stated the rationalization for the recall was because there was this lack of logs. Is that correct?
Only in part.
Okay, what was the second part of that?
That there were clear deviations from the SOP.
Okay, what were the clear deviations
Temperature,
specific to aspergillus?
not specific to aspergillus.
So you're talking about a temperature not related to aspergillus, but the recall was related to aspergillus test, correct?
I believe so. I think in part it should be all microbials because the uncertainty is present for all microbials.
Well, I don't understand that.
I don't understand that either. Can you explain it?
You just said that the deviation from the standard operating procedures was not the log, which I think you said before, but was the temperature, which is somewhat vague, but then council asked you, did you say, what was it? Temperature is not related, the temperature is not related to the
Aspergillus.
and you agreed with that, correct?
I agree that clear temperature deviations were not related to aspergillus. Yes.
Okay. Okay, I'm sorry, go ahead.
No problem.
Just writing my notes.
So I just want to be clear on this. Then the recall was issued because of these temperature variations as opposed to the absence of logs?
The issue with the recall is that the licensee was unable to demonstrate that they were following the validated procedure.
Okay, and I want to be clear about this, but the validated procedure you're talking about is in the SOP. The procedure that they use, the standing operating procedure, is what's set forth in the SOP, accredited by the A2LA, and then approved by the MRA, correct?
That is correct.
Okay, and Viridis never deviated from the SOP when it was testing for aspergillus, correct?
There is no way to be certain of that.
But you issued a recall based on what you claim were unreliable results related to aspergillus, correct?
That is correct.
So you can't be certain of whether they followed the SOP or not, but you issued a recall based on aspergillus results. Is that what we just testified to?
Any uncertainty as it relates to the validity or execution of a method is enough uncertainty to bring me serious concern about public health, safety, and welfare.
Well, can I ask a question?
Sure.
Because one of the arguments that the plaintiffs are making is that clearly the MRA has the authority to issue a recall. But there doesn't appear, at least as far as I've seen, and maybe I've missed it, any written standards for what suffices to institute a recall. Are you aware of any internal documents that set forth criteria to apply? And, you know, because I assume not every deviation from a standing operating procedure results in a recall. That would be pretty hard to conduct business that way.
So that's a great question, Your Honor. As a follow-up to that, those samples that our attorneys were talking about that were retested that had originally passed, well, had originally failed at a different safety compliance facility, passed at Viridis Laboratories, then subsequently failed when retested, is what my directors, I believe, used as their designation for issuing the recall.
Okay, but that, I appreciate that answer, but my question was, is there anything in writing that gives guidance to the agency, you know, created by the agency itself, as to what suffices, you know, a minimum threshold where a recall is on the table?
I honestly do not know the answer to that.
So what you just testified to is there's no guidelines set forth by the MRA as to when they're going to issue a recall. Is that correct?
No, what I testified to is that I am not aware of those guidelines.
And your position is the scientific and legal manager for the MRA?
That is correct.
Would you agree that you're the highest ranked scientist at the MRA?
In terms of structure, yes.
Are you the most qualified scientist at the MRA?
My LSSs are most qualified in terms of the fact that they have their PhDs. I have the most qualification as it relates to cannabis industry testing experience.
You testified that the results were unreliable so that you needed to issue a recall, or that's why you issued the recall based on the aspergillus, correct?
Correct.
And you began investigating these aspergillus test results based on something you found from Metric, you stated. Is that correct?
Yes.
Okay, so you were watching Metric and you see that retests are sent to Viridis North or Viridis Lansing, and they're passing those tests. Is that correct?
That is correct.
And isn't it true that the MRA has a rule that allows for a grower when a test fails for aspergillus to have it retested?
Absolutely.
So there's nothing wrong with a grower taking a product to another lab and having it tested. Is that correct?
Correct.
There's a process in place for that.
Mhm.
Is that a yes?
Yes.
So the fact that you have that process in place indicates that the MRA recognizes that two separate labs may get different results. Is that correct?
I don't think that's why that's set up that way, no.
Well, there wouldn't be any other reason to have a retest, would there? If the two labs would never get the same results, why wouldn't you always just rely on the first test?
To allow growers the opportunity to remediate their products, that they don't have to destroy product that failed.
Do you know if these specific tests, the 10 that you're talking about that were retested, they were never remediated?
The 10 that were selected randomly. So no, I do not know if those were remediated or not.
The MRA does not require remediation prior to the retest, correct?
That is correct.
The 10 tests that the MRA relied on, they were sent to competitor labs. Is that correct?
Yes.
And there was an email that was sent out from the MRA to these 5 competitor labs, letting them know that an investigation was taking place, and they were asking them to do a retest on, I believe, potency and aspergillus only. Is that correct?
That is correct.
So the retests themselves were related only to aspergillus. No, had nothing to do with total yeast and mold, correct?
That is correct.
Well, it's for, I think it's a potency and.
Potency and aspergillus, Your Honor.
But aspergillus was the only one at issue.
Right. Well, the reason I bring that up, Your Honor, is because the indication of the total yeast and mold that was testified to earlier. Prior to the recall being issued, there were correspondence back and forth between the MRA and the folks at Viridis related to the retest. Is that correct?
Yes.
Did you learn from some industry experts that they had concerns about these retests?
That was stated, yes.
Okay. And can you tell us who those people were?
That would be Patrick Bird and Maria McIntyre.
Okay. And what was it that you learned from Maria McIntyre and Patrick Bird? She can certainly testify to what she learned and how she, how it.
Right, I agree, overall.
I, to be honest, don't recall what they had said in the emails.
Your Honor, do we have a way to show, to refer to
Not that I'm aware of.
camera?
I mean, the witness acknowledged that that she saw the email, right? And that there were statements from those individuals that expressed concern about certain aspects of retesting, right? Thought you did.
Yes, I believe she did it. And I'll continue while they're looking for those emails. You indicated that the two industry experts were Patrick Bird and Maria McIntyre that had indicated they had concerns with those retests. Is that correct?
Yes,
And are you familiar with Patrick Bird and Maria McIntyre?
yes,
Okay, and are those experts that you personally rely on in your day-to-day job?
No.
Do you ever speak with Patrick Bird from the AOAC?
yes,
And would it be fair to say that he is an industry expert as it comes to concerns testing of methods such as aspergillus?
he is certainly knowledgeable about those methods, yes.
It's exhibit 3 that you're talking about, isn't it? From yesterday, the email?
Yes. I don't think I have a way to show the witness the exhibit to refresh her recollection on it with her being on Zoom. That was the
Right.
problem. Do you have the complaint in front of you or near you?
Are you speaking to me?
Yes.
Yes, I do.
Okay. Can you look at exhibit I?
I certainly can't.
Looking for the last page of I.
Goodness gracious. Mm. Let's- Believe I'm there. Okay. Yep.
Okay. Would you read that email and see if that refreshes your recollection on what you learned from Mr. Bird on November 17th?
Do you want me to read it aloud or?
No, you can just read it to yourself.
Okay.
Well, it may be, but I don't know that he's gonna ask her to admit the statements. It's just what I assume it's gonna be, what action, if any, did you take in light of this information? But I don't know. We'll wait and see what the question is.
Okay. I've read the email.
Okay. And what did you learn from Mr. Bird's about his opinion about the recall as it relates to the retest?
So as it relates to the retest specifically,
Yes.
it seems as though he has concerns about, the batch having different test portions analyzed, time gaps in analysis, et cetera, that may impact the accuracy of those test results.
And that he didn't believe that the recall was supported by these retests, correct?
By the retests alone, I believe that is correct.
In addition to that, you received correspondence from another expert, Maria McIntyre, is that correct?
Mhm.
Okay, and who is Maria McIntyre?
Maria McIntyre is, I believe,
Yeah, it was a yes. It was a-
yeah, sorry. Is the cannabis expert
Hold
for,
on a second, Ms. Patterson.
Sure, I'm sorry. Okay, I said, who, can you tell us who Maria McIntyre is?
yes,
Can you go ahead and tell us who
Yes.
she is and what she does? Thanks.
Maria McIntyre, I believe, oversees cannabis testing for bioMérieux, which is the product vendor for the method that the laboratory is utilizing.
And is that the instrument that the labs use for aspergillus testing?
Yes,
So it would be fair to say that Maria McIntyre was an expert in the use of this instrument?
yes,
And Ms. McIntyre too opined on this issue of the recall, correct?
as it relates to what, would you please clarify?
Well, let me ask you first, during those conversations, isn't it true that there were two delineated reasons that the MRA was setting forth for issuing the recall prior to the recall, which were related to the retest that we just talked about, and then
Mhm.
also the lack of the incubation logs. Is that correct?
Lack of empirical proof that the method was being adhered to, yes.
So you're saying that the reasons that the MRA set forth weren't specific to these 10 retests and the lack of the logs?
No. I'm not sure I understand the question. I apologize.
Okay, I'm sorry. I'll try to be more direct. Did the MRA or did you state in a phone call to Viridis employees that the reason for the proposed recall were related to the 10 retests and the lack of the logs for samples going in and out of the incubation machines?
I believe that is correct.
So those, we can agree that those are the two reasons that the MRA delineated for the recall, at least at that time, correct?
Correct.
Okay. And so you received an email from Maria McIntyre related to this proposed recall, correct?
I believe so, yes.
Okay. And what did you learn from that?
To be honest, I believe it was exactly the same thing that Patrick Bird had said.
Okay. So you had two experts that thought this recall was inappropriate based on the delineated reasons set forth by the MRA at that time. Is that correct?
Only on one of the delineated reasons, yes.
Okay, let's talk about which delineated reason did they not opine on?
So they arguably did not support the basis of the recall being based specifically on the retests. However, my conversations with Patrick Bird very clearly indicated that he did support.
That's hearsay. So I just want to talk about what you learned from these emails and what you did about it.
They took issue with the testing that was done as it related to the recall only.
Because they didn't believe it was an accurate representation of the original test from Viridis, correct?
That it may not be an accurate representation. I believe that is correct.
And based on that information, you still went forward with the recall, correct?
Yes,
So you indicated that they only disputed one of the delineated reasons, which was this lack of logs. Is that correct?
they did not dispute the lack of logs being problematic.
Well, didn't you learn from them that they thought that was an accreditation issue?
No,
The lack of the logs as the MRA comes in and they do on-site visits often, is that correct, to the laboratories?
Can you repeat that again? I'm sorry.
The MRA, they come on site to the laboratories often, is that correct?
Yes.
They have the right to walk in the laboratory at any time, is that right?
In a post-COVID world, it's a little bit different, but overall, yes.
Fair enough. So is it true that Viridis, the two separate laboratories have been in existence for a couple of years now?
They have.
Okay. And from the inception of both the laboratories, the MRA has governed them and been on site and watched what they do, correct?
A number of times we have been on site. That is correct.
Okay. And you are aware that prior to November 16th or 17th, whenever was the first time the MRA brought this issue to their attention, Viridis Laboratories in Viridis North never had a log for samples going in and out of the an incubator, correct?
I was not aware of that until we found that out on October 26th and 27th.
Well, if you're monitoring the labs, you had the ability on the day one that they were open to make a determination when you watched to see how they were conducting the test, correct?
Except for the course of the past nearly 2 years that we've been in the pandemic. That
You
is
had the ability to do that, correct?
prior to the pandemic and after June of 2021. That is correct.
And you never once issued any kind of notice, deficiency, complaint, anything against Viridis as it related to this lack of logs from day one, correct?
No, but if that would have been something that we noticed, we absolutely would have notified the licensee of that.
But at the time that you started discussing the proposed recall with Viridis, Viridis openly discussed the fact that there were never logs, that they believe that this was an accreditation issue, not an issue that related to anything the MRA could punish them for because they were following their SOP, correct?
I don't know about that.
It was never a secret. They never made a secret of the fact that they didn't have a log that kept track of the sample going in and out of the incubator, correct?
No, I agree with that.
And with that knowledge, you did a recall from August 10th to November 16th, correct?
Yes, that is correct.
Based on your rationalization, if the retest were,
You mean, when you say you mean the MRA?
I'm
She
sorry,
was not
yes.
a decision
yeah,
maker.
right. Well, she's one of the decision makers, though.
I thought you testified that you didn't make a decision.
The final decision is not up to me. I'm a part of the conversations, Your Honor, but these decisions are above me.
And you made a recommendation.
I wouldn't even state that I made a recommendation. I'm here to present facts.
Did you give input?
Yes,
Okay. And was your input related to the dates that the recall would affect?
no,
Who made the decision on when the recall dates, what the recall dates would cover?
I believe Mr. Mitchell.
And so I was starting to get into the recall covered August 10th to November 2016, correct?
November 16th of 2021. That is correct.
So if the recall was based on no logs, then really the recall should have been since the first day that Viridis was open, correct?
I agree.
Was that your recommendation?
Yes, it was.
And that's not what the MRA did, correct?
That is not what the MRA did, no.
I believe the email went out on October 25th, 2021, asking their labs for the retest, correct?
I'm not sure.
You, meaning you yourself, and I believe two others from the MRA were on site on the 26th and the 27th.
That is
Meaning
correct.
Viridis Lansing and Viridis North, correct?
Yes,
Okay, so you were on site, and that was the first time in 2 years that that anyone from the MRA, although you had like 4 people there, that realized that these logs weren't in place, correct?
correct.
On October 25th, when you realized these logs weren't there, did you issue a recall or any kind of safety notice to the public that day?
On the 26th or 27th of October?
Yes.
No,
But if it was a real health and safety issue, it would have made sense to issue a notice to the public on that day, correct?
I think we would need to notify the laboratories of our intent first.
Okay, well, let's get into that. What requirements does the MRA have to give the lab notice?
In what capacity?
Well, you just said that you wouldn't issue a recall on the 25th to the 26th, even if it was a health and safety issue, because you had to give the laboratories notice. What requirement do you have to give them notice?
I mean, we don't technically have any requirement to give them notice because it was a 2-day audit. And I believe you were talking about the first day of the audit. I don't think it would make sense to do something like that without having looked at both laboratories.
Okay, so on the 28th, October 28th, you didn't issue a recall either, correct?
That is correct.
And you had knowledge that on the 28th that the laboratory wasn't keeping this log that you deemed so necessary.
Correct.
And then the retests themselves, those came back on November 1st, 2021 and November 5th, 2021. I believe 90% of them actually came back on November 1st, correct?
I'm not certain.
Okay, so assume that I'm correct, and I believe that's part of what's in our complaint. I won't make you go through that, but would it be fair to say that the first week in November, you had the knowledge about the lack of the logs and also the knowledge about what the retest had shown?
I don't know when we received that data now.
If the evidence shows that the MRA had knowledge of the lack of the logs in the retest on November 5th, in your opinion, would it be necessary to issue a recall immediately, right that day?
Those decisions are not up to me.
I'm asking what your opinion was.
My personal opinion, I don't think matters in this case, but
But I'd like to hear it. Your Honor, the defendants in this case offered Ms. Patterson to rebut the scientific information and the justification for the recall. She's now on the stand to testify about those justifications. I have the right to ask her opinion about it.
But you're not, what you're asking her is about the ultimate decision as to when the recall was issued, not the scientific basis for it. And your point's been made anyway. I mean, so if the verified complaint says it was November 1st and 5th, and they still waited 10 days or whatever it was, I get the point. I don't need Ms. Patterson, a non-decision maker, to tell me the same thing.
Ms. Patterson, did you previously work at Iron Laboratories?
I did.
I'm sorry, was that a yes or no?
I did.
Okay, and is Iron Laboratories a similar laboratory to Viridis North and Viridis Laboratories?
They are a licensed safety compliance facility in Michigan, yes.
Okay, so they do the same thing as the two laboratories, correct?
Yes,
Were you aware of a complaint that was filed by the MRA against Iron Laboratories in 2019?
I was aware of it, yes.
You were aware of it?
What?
A complaint that was filed against Iron Laboratories in 2019, the laboratory,
By the agency?
by the MRA.
It was like a circuit court complaint or an administrative?
an administrative complaint, a formal complaint, Your Honor.
What is the relevance?
The relevance is the severity that they put in the complaint and the summary suspension and the process in which they did that, and then the fact that they didn't issue a recall, Your Honor.
Well, I don't know. I mean, it's obviously different circumstances. And we're not going to litigate the situation that involved this other entity. So how's that gonna?
Your Honor, respectively, you have an issue with another laboratory that's similarly situated that was accused by the MRA of falsifying records, purposely falsifying records. And these were for pesticides that are deemed by the MRA to be highly dangerous. And they didn't issue a recall, although they had a formal complaint and a summary suspension. I want to know why. I want to know what the process is.
And what claim does this go to?
This goes to the fact that we're likely to success on the merits based on the fact that the MRA has no guidelines whatsoever, and they are issuing improper rules as they go to make a determination when they're going to issue a recall. The licensees have no way of knowing what's going to trigger a recall. In this situation, they find pesticides, they issue a summary suspension. Viridis would have been better off if they received a summary suspension. They'd have been in front of a.
Yeah, I know. That's all in your brief. Why don't we just ask the witness, one, if she's familiar with the complaint that was filed? Were you, ma'am?
I am only familiar with the fact that the complaint was filed. I had nothing to do with the process itself.
Okay, and did you have any discussions with anyone at the MRA about why a recall wasn't done with respect to, what was it called? Iron something?
Iron Laboratories.
Iron Laboratories?
No, Your Honor, I, upon employment with the MRA, have been forbidden to have anything to do with any of Iron Laboratories files.
Am I able to explore this with her or no?
I mean, this is not a trial on the merits, okay? I know you have an equal protection argument, but this is, you know, we are, I'm losing my patience, not with you, but with the fact that I'm allowing all this to happen. I maybe I'll be wrong when I look back at the briefs, but I'm sitting here thinking we are, you know, a preliminary injunction is an extraordinary remedy. And it is not the case in this state that any unhappy company that is subject to an agency can come in and just have an evidentiary hearing on challenging the factual basis for a decision being made. And that's what I feel like we're doing. I mean, I know there are other points to this, but we're not going to sit here all day and continue on and question about every decision the MRA's made and compare it to yours. This is not what an injunction hearing is all about, okay?
I understand, Your Honor, but the reason that we have to get into that is the likelihood of success in the merits, and you know, to explain their justification for doing this. I understand.
But look, we've already established. Look, well, first of all, a lot of this is legal stuff, right? I read the statute, I read the rules. We understand. I think it's been clear with both witnesses that there's no written guidelines with respect to how do you determine when to issue a recall? What is the basis for doing that? I don't know if there has to be a basis for that. Maybe that's going too much into the nitty gritty that the agency has to decide. I got that point, okay? And you know, I mean, so no, we're not going to go into what happened. Maybe whoever takes this case over for me, because I'm done at the end of the year, and you have a trial or summary disposition after discovery, maybe so. You can get into all that stuff if it goes to equal protection claim, but I'm not going to open it up to litigating, especially when she's already testified she doesn't have any knowledge about any of this.
I'll move on, Your Honor.
All right.
Are there ongoing complaints against Viridis?
Yes,
Okay, and related to microbial?
yes,
Okay, so it's fair to say that any day today, you could put a hold on a sample related to this ongoing investigation. Is that correct?
to any ongoing investigation. That is correct.
Right. So you have the ability through metric just to put those samples on hold, correct?
If warranted, that is correct.
Okay, so while there was testimony yesterday that Viridis is approved to move forward and test, this is an ongoing investigation that at any time they could once again find themselves unable to test.
If they were to do something again that would make their results uncertain,
So
that would,
I just want to get right to the point, and Judge Murray's obviously indicated that he wants me to do that. You had the ability just to put things on hold during this ongoing investigation in these microbials. You don't believe you're required to give any type of notice, to issue any type of formal complaint like Iron Laboratories received. Your position is that you have the ability just to put them on, put samples on hold like you did the last 2 weeks, and there's no need for a hearing. Is that correct?
if there are samples that we believe may be a harm to public health, safety, and welfare, it is part of our internal procedure to place those samples on administrative hold until an investigation is complete.
So the answer is yes. That's a likely possibility that will continue.
I wouldn't state that, no.
Is it fair to say that you have suspicions about Viridis testing,
Not currently.
but you have an ongoing investigation?
I have several ongoing investigations, yes.
One of the ongoing investigations you have is related to potency, correct?
Yes, sir.
And I don't want to get into the details of that, but I just procedurally with that, you filed 4 or 3 formal complaints against Lansing and 3 against Bay City, correct?
I'm not sure of the total number.
Okay. That's with that, with the formal complaints, Viridis has the right to a compliance conference, which they've already had, correct?
I believe so, yes.
Okay. And then after that, they're entitled to have a contested hearing, correct?
Yes,
Okay. And if you were to determine a summary suspension was necessary, they'd be entitled to a hearing within a certain amount of time, correct?
yes.
Okay. But when you put samples on hold like you did for the last 2 weeks, or you may do in the future, they have no right to an immediate hearing, correct?
To an immediate hearing, no, because the samples are being investigated as part of the investigatory process. But they will eventually go to the compliance process, as is our procedure,
So no notice is required though.
other than the notifications in metric, no.
So they find out when the customer tells them that their sample's been held up by metric, correct?
I do not know when they find out.
But that could be a way that they could find out, correct?
That is certainly a way they could find out.
And likely a way they'd find out because a customer isn't happy when their sample gets put on hold in metric, correct?
I do not know the status of the customers.
But it'd be fair to say that if a customer has a sample put on hold, they're not going to be very happy, correct?
I can't speak to that.
You've never heard from a customer that was unhappy that their sample was put on hold?
Personally, no.
Have you ever heard from anyone at the MRA that customers weren't happy because their product was put on hold?
Yes,
And what have you ever heard a reason why that would make them unhappy?
no.
As part of the recall notice, you allowed for retesting of recalled products. Is that correct?
Yes,
And would it be fair to say that the recalled product was about 60,000 pounds worth of product?
I do not know how much it was, no.
And would it be fair to say that the retail value of that product was over $220 million?
I do not know that.
Would it be fair to say that the majority of that product is still in the pipeline, meaning it hasn't gone out to consumers?
I do not know that either.
But you have that information, a metric, if samples are placed at hold or where they're at, correct?
In the fact that it exists in metric, yes. Is that readily accessible and easily digestible by myself? No.
Would it be fair to say that the MRA has attempted to facilitate getting this recalled product to market?
Yes.
Okay, would it be fair to say that in fact, the MRA is now diverting from its own rules in order to facilitate getting this product to market?
No.
You've not diverted from any rules to get the recalled product to market?
Not that I'm aware of, no.
How is, strike that, the product, the recalled product, that's deemed a failed sample at this point, is that correct?
I'm afraid I don't understand.
I'll try to make it more clear. So if a laboratory, well, Viridis is holding a sample that they tested, they passed, it's part of the recalled batch, that product is now deemed a failed sample, correct?
I don't think it's deemed a failed sample, no.
Okay, so is it deemed a pass sample?
The results are uncertain.
So you're allowing a retest of that product to be sent out, and because the laboratory, Viridis Laboratories and Viridis Lansing were precluded from testing for 2 weeks, they had to transfer that sample to other laboratories to have those laboratories retest this already tested product, correct?
Nobody forced the laboratory to do that, no.
So their other option would have been to keep the product at Viridis until the MRA decided they were going to let them start testing again.
I am confused by your question.
In order to get it retested after the recall, November 17th, because Viridis wasn't allowed to test microbials, in order to get that product tested, wouldn't that have to be transferred to another lab?
No, not necessarily.
But Viridis couldn't test it, correct?
There's nothing stating that Viridis couldn't test it, no.
But it would get, if they did test it, it would be put on hold, correct?
It would depend on whether or not it was part of an investigation.
In fact, you were on emails from Desmond Mitchell that stated that they couldn't test until they met certain criteria, right? And I'm not going to go in deep into this because we went into it yesterday, but I just want to make sure that you do recognize that fact.
I know that we were working with the laboratory to correct audit findings to ensure that they were performing tests in accordance with their validated methods.
And you were on emails back and forth that specifically stated that Viridis Laboratories and Viridis North didn't have the ability to do microbial testing until, I think, Thanksgiving.
I was on emails back and forth with them that were addressing audit findings.
Nothing to do with the fact that they were trying to get back online to be able to test.
They were trying to come in line and in accordance with their validated methods, yes.
Okay, just for the sake of this question, you don't seem to remember that. Assuming that Viridis was able to retest that product on November 18th, let's say. So
Sure.
the recall product, they're holding it. The recall notice states that it can be retested. Is that correct?
Yes,
Okay, so in order to retest it, they're retesting a product that's been handled by Viridis once through the testing process, correct?
some portion of it may have been handled, yes.
Okay, so it would be fair to say that that product may have been, may not be in the same original condition as it was prior to that test?
It may not be in terms of its physical appearance, but I believe that Viridis Laboratories employs the use of single-use laboratory, forceps, tweezers, things of that nature to ensure non-contamination of those products.
So if it was deemed a failed test, it would need 2 retests, is that correct?
That is correct.
Okay, so you weren't deeming the product that had been recalled as a failed test.
We were deeming the results as being uncertain.
What does that mean? Was it a treated as a new sample?
There was uncertainty about the accuracy of the test results. They may be failed, they may be passed. And that's what we're
Okay.
determining now.
So if the recall product was treated as a failed product, it would have to be retested twice, correct?
That is correct.
So you're not treating it as a failed product.
Not specifically, no.
Okay, and in addition to that, the MRA is now allowing packages that are sitting on a provisionary center shelves to be taken off and those to be retested, correct?
That is correct.
So that is a diversion from the MRA rules, correct?
I don't believe so, no.
So prior to the recall, it's your testimony that the labs had the ability to go in and retest the product that's already on shelves of provisionary centers?
Yes, as they did during the EVALI crisis.
When a sample is sent to a provisionary center, and it's usually in a larger batch that then gets broken up, is that correct?
I do not know.
You don't know what happens to a sample once it goes to provisionary center?
I don't.
Have you heard, sorry, you look like you're frozen there. Have you heard complaints from customers, or have you heard from others in the MRA? There's been complaints from customers that their product hasn't been able to go to market since the recall?
No.
I'm asking what she's heard from other MRA colleagues. That'd be a mission of a party opponent.
How would that be an admission of a party opponent? It's other customers?
Yes. No, what they've heard, if they've told her that they've heard complaints.
I've not heard complaints, no.
So there's been no issue in the industry from the recalled products and a bottleneck that's occurred with the inability for growers to get their product to market.
You asked me if I'd heard complaints. I said no.
Okay, so had you heard an issue that there's a bottleneck in the market of growers not being able to get their product to market?
I have not heard that, no.
Okay, so there hasn't been any issues that you're aware of?
That I am personally aware of that have been brought to my attention, no.
Well, what do you mean personally aware of? Are you aware of any?
Well, what difference does it make? I mean, if there's a bottleneck and it was a justified recall, oh well, right? I mean, that's the consequences of legitimate action, right?
Well, Your Honor, it wasn't a justified recall, and obviously this goes to the damages element that we're seeing now, and the fact that, you know, the court yesterday somewhat indicated that the recall happened and we're moving on. This recall, we're in the middle of the recall. This product is all bottlenecked. It's all still held at these labs. So your opinion on this injunction is very important, and I want to make sure that this point is driven home.
All right.
So just to be clear, what I'm asking you is a lot of the product that was recalled still either held at a provisionary center where it can't be sold because it hasn't been retested, or still at a laboratory?
I do not know the answer to that. As I stated earlier, some 800 packages have been tested. So those have results and should be available for sale.
You stated in your testimony earlier that there was health effects that you were aware of from reports to the MRA, correct?
Adverse reaction reports, yes.
But you know, those weren't used as a justification for the recall, correct?
Correct.
But that was information that you gathered for today's hearing, correct?
No, that's information that's reported to the MRA regularly.
When you say regularly, what do you mean? Do folks typically call in to the MRA with issues?
It doesn't happen very often, but it does happen occasionally.
But again, that wasn't a rationale that the MRA used.
No, it occurred after the recall.
You talked about the lack of the absent of proof following the procedures was one of the reasons for the recall. But the MRA requires that Viridis Laboratories and Viridis North does proficiency tests, correct?
That is correct.
Okay, and just in July 2021, both laboratories had passed proficiency tests as to all of the methods, correct?
I don't know specifically the details. I'm
But
assuming,
you are aware that that's a requirement that the MRA has, that they pass proficiency tests, correct?
yes,
And isn't a proficiency test the best way to determine whether a laboratory is actually using a validated method correctly?
no. It is part of a greater package, arguably.
So you think that the better way to do it is to send out samples days or a long time after that they've originally been tested to competitor labs as opposed to a proficiency test?
That is not what I stated.
Okay, so what is the better way to make a determination that a lab is properly testing its method?
Well, the best way to ensure that would be for the lab to follow the validated method. But ultimately, what we would look at is proficiency testing in correspondence with quality assurance, quality control, day-to-day oversight by the laboratory management staff, inter and intra-laboratory comparisons. I mean, operating a laboratory isn't something that occurs in a vacuum or a silo, and it certainly is not merited by passing a proficiency test in and of itself.
But that's the way the purpose of the proficiency test is to make sure that there are accurate results, reliable results coming out of the laboratories, correct?
Again, it is one of the ways to look at that.
In another way is that they're accredited by a accreditation body like the A2LA, who reviews all of their methods and their SOPs and determines whether they're going to issue that accreditation, correct?
That is another way, yes.
Okay, and both of these laboratories are accredited by the A2LA, correct?
I believe so.
And I think you testified that there was no trust that that Viridis was accurately reporting these results, correct?
Given the data that we had, that is correct.
Okay, so wouldn't that be a perfect example of it being necessary to issue a summary suspension?
I do not know the answer to that.
Well, what criteria do you use to make a determination whether you're going to issue a summary suspension if you think a lab is producing inaccurate, unreliable results, as opposed to waiting 3 weeks after you had knowledge about logs and issuing the largest recall in Michigan history? How do you make that determination?
I personally do not make that determination.
Well, do you make the determination of whether a summary suspension is given?
No,
When you say largest recall in Michigan history, I haven't heard that as a fact. You're talking about with respect to marijuana?
Correct.
Okay, so that goes back to 2016 at the. Right?
I'll ask the witness. Are you aware of any recall that's been for more product than what was recalled from these two laboratories?
again, I don't know the amount of product in this recall versus any other recall, no.
Have there been other recalls done by the MRA in the last couple of years?
Yeah,
Okay. Yeah, just one follow-up thing. I'd ask you about this complaint for the potency method. That complaint has nothing to do with the recall, correct?
correct.
Nothing further.
Okay, thank you. You direct? Okay, because
I'll do my
we're
best.
running out of time.
I understand. Patrick Bird, you had a discussion with him over the phone, is that correct?
Yes,
And earlier you were asked whether he believed the recall was supported by the retests, and you said generally, no, he didn't agree with that, correct?
Correct.
But did he give you an opinion as to whether the recall was warranted or other reasons?
Objection.
Yes.
Sustained.
It's,
He never testified about what was said by Mr. Byrd. I mean, you can ask her did you have a conversation with Mr. Byrd after you saw this email? Yep. Okay, did you then continue with she didn't even make a recommendation about the recall, so, did you do anything in relation to what, after you talked to Mr. Byrd on the phone? Yeah, okay, then what did you do? But we're not gonna get into what Mr. Byrd told her.
I understand and appreciate, if I may just note a reason or rationale why I think this may come in, I'll keep it short.
Okay,
I believe that Mr. Byrd relayed information to Ms. Patterson that she then relayed to the team that added to the reason for the recall.
Objection,
Correct.
she's saying hearsay.
It's,
well, no, it's, look. Again, did you talk to Mr. Byrd? Yes. Did you then go talk to the group? Yes. Did they continue with a recall? Yes. Okay, nothing more than that. So go ahead and ask her. I'm just giving you examples, I'm not testifying to it.
so you had a conversation with Mr. Byrd, correct?
Correct.
And did you relay that information to the other of your team members working on this issue?
Yes.
And ultimately, Mr. Byrd's information relayed to you was taken into account by the team, is that correct?
Correct.
Similarly with Maria McIntyre, did you have a phone conversation with her?
Not prior to the recall, no.
Okay. When administrative holds are placed on product during investigations, those holds could be released if the investigation deems that product is safe, correct?
Correct.
And that happens, not infrequently, correct?
Correct.
So after you did your October audits, that's when you decided to have the retests,
Correct.
and you received those results early November, is that correct?
I believe so.
Oh, okay. And did it take some time to evaluate those tests and determine whether or not that this recall was necessary?
Of course.
You didn't want to make a rash decision, did you?
Objection, Your Honor.
No.
It is, you're right, it's leading, so
I'm sorry, I was just trying to.
I understand,
Okay.
but he objected and he's right. So.
I appreciate that. What kind of care was made in making this decision for the recall?
In terms of the
Objection.
considerations,
I think we've already established that she didn't make the decision. I was precluded from a line of question just on this path.
I agree. She can testify, I think, based on what she's about the labs, the scientific stuff. She wasn't involved with the decision. Okay, I mean tangentially, but she didn't make the decision. So let's avoid questions relative to that.
As far as the science, did you take time to evaluate everything to make sure that you were making a fact-based, science-based recommendation to your team?
absolutely.
Thank you.
All right, Ms. Patterson, that's the end of your testimony. Thank you for your time. Appreciate it and have a good rest of the day.
Thank you, Your Honor.
All right. Other witnesses that defendant plans on calling? Sure. Pardon me, I can come back. Okay,
Or we would like 30 minutes, please, to do rebuttal witnesses. 30 minutes only. This is as to the issue we discussed yesterday.
but
As to, this is the effect on the entire industry. This is, the recall's not over, is causing irreparable harm every minute, literally, that this, that
to your, but it's gonna be limited to your client.
my
Irreparable harm.
irreparable harm is geared toward the client, yes, but to help accentuate the points that were made in the amicus brief from the chamber, that this is literally affecting the entire industry. It touched 400 some stores.
Okay. All right, and you
Okay.
have the witnesses ready?
I do. So my suggestion, respectful suggestion, Your Honor, is we could either do the 30 minutes now and then break for lunch and do closing, or we could do both after, or do you want to get it all before
I'm
lunch?
not breaking for lunch.
Okay, understood.
And the closings are gonna be very, very short, because I have your briefs.
I object to any rebuttal witness. Clerk Patterson's testimony, add to the original presentation.
Your Honor, we discussed this yesterday. I think we were off the record at the time, and we said that we were giving advance notice that we intended to do this. And Your Honor said that we could do this. And this also was,
All right, well, look, you're right. I don't think it's, I mean, they asked questions of Ms. Patterson about it, but she didn't really have answers, so it's not really rebutting anything, so you're right. But it does go to some of the factors for a preliminary injunction. And so we'll take that testimony now if we can. Maybe, did you get a chance to take a break too already? Okay. Okay, I just want to make sure. Yes,
thank you, Your Honor. Please would call Mr. Greg Mashad. He should be in the Zoom waiting room. Planning to be here in person, Your Honor. He's sick, and so for
okay, that's all right.
Yeah.
I'm not a big fan of Zoom, but,
Judge Murray, there is nobody in the Zoom waiting room right now.
oh, there's not?
No.
Is he the only one that you were gonna call about this?
No, Your Honor. We have potentially 3, but I asked for a time limit on purpose because I know you want us to move along, and we will use our 30 minutes accordingly.
Okay. But you don't know, apparently none of them are. Oh, okay,
Sorry about that, Your Honor.
that's all right.
You want to say we have 3 witnesses, and you know, that's why we asked for time on
And
purpose.
listen, I mean, I want to apologize. I don't mean to be, short with anybody. I just, it's not the time as in the time of the day that I have to do this. This is what my job is, but it's my, and I'm not talking about the witnesses you're going to call now. It's just the getting into the nitty gritty of an agency decision and seeking a court to enjoin that. And that's something for later, but that's what's getting me a little bit perturbed. So I apologize.
Judge Murray, there is a Gregory in the waiting room. Is that the person you're looking for?
Yes.
Okay, he's coming in. Sorry.
And Greg, what?
Greg Mashad,
Shot.
Michaud, CEO of Viridis.
Oh, okay. One of the 3 co-owners.
Correct.
Good afternoon.
Good afternoon, Your Honor.
How are you doing?
We felt a little better, a little under the weather today.
Oh, well, I hope it's nothing serious. Anyway, I'm gonna have to swear you in before you give your testimony, okay?
Yes, sir.
Would you raise your right hand? You swear and affirm that the testimony you provide in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you.
excuse me, do you need his name again spelled? Okay, thank you. Good afternoon, Mr. Rashad. Can you explain to me your title, please, relative to Viridis Lansing and Viridis North?
Good afternoon, Mr. Blair. And my name is Greg Michaud, and I'm the CEO founder of Viridis Laboratories, LLC and Viridis North, LLC. One of the original of 3 founders for both of those companies.
Great. And very briefly, could you just tell me a little bit about your background?
Sure. I retired from a 26-year career back in 2016 with the Michigan State Police. I graduated from Michigan State University and hold a bachelor's degree in a double major of criminalistics and chemistry, and started with the state police in 1990. And as I said, retired after 26 years. Majority of that time was spent in the forensic science division, nearly 21 plus years of that. And I retired as the director with the rank of captain of the forensic science division. That was a laboratory system of 8 public funded laboratories, one of the largest laboratory systems in the nation at that time.
Sorry, Mr. Rashad, I don't mean to cut you off, but we're trying to move through some of these things quickly.
Yes, sir.
As of this morning, how many retest samples are in the queue resulting from the recall? We are talking only about the recall and not the de facto suspension that we've talked about before. Only the recall. What is the current queue of samples to be retested?
Yeah, so there's 2 facets to that. The one are the ones that we're going out and collecting today, and then the second are the ones that we have in-house that we haven't currently outsourced to other laboratories. So over the past 3 days, we've collected over 544 samples across the 2 laboratories that are strictly retests. And then today we're collecting 50 to 60 additional, and then tomorrow we have 125 additional samples. And we foresee this going into next week and beyond as well.
So
Now,
if I could just put a fine point on that, the recall isn't over, is it?
oh no, sir, we're just starting with the recall.
Okay, and how many samples are currently on hold between the 2 labs?
Well, within the metric system and the administrative holds that are Viridis related, we have over 4,240 at this time. That doesn't count the ones that we've collected today. When we go out and collect a retest, then that number climbs for the administrative holds as well until it gets through retesting. And if everything passes, then it gets taken off of those holds.
So it's 4,200. We're going to use round numbers and round down just so we're not 4,200 between the 2 labs. How much at Bay City versus Lansing? And round numbers is fine.
Yeah, 2,400 at Bay City and 1,800 at Lansing.
Okay, and again, these are numbers that are you expect to increase, not decrease as this goes on, correct?
Correct. Us going out and collecting samples from the growers, the processors, and the provisioning centers, we expect to carry on for a good 2 to 3 weeks here at least. And talking with our field supervisor at least. Now, the other part of this are the in-house samples that we have that the customers have been reaching out to us to ask us to retest as well.
Okay, so just to kind of explain that real quick, there's the stuff that was in-house at Viridis on the 17th, right?
Correct.
And your customers, some of your customers have asked you to ship those out for the recall retesting to your competitors, right?
Correct.
But some of it is still on your shelves. And so that's the piece you were going to talk about that's still in-house, that you have those tests on top of the numbers you just gave were the stuff that has been collected in the last 3 days, right?
That is correct, yes.
Okay. And do you have an approximate count on the number of samples that you never left in-house but still need to be retested?
Correct. For Bay City, we're looking at an additional 550 tests that we'll be having to do. And then Lansing currently has an additional 200 tests.
Okay. And how long do you expect those tests to take?
Well, with our current capacity to get through those tests, I mean, we're doing about 80 to 85 tests a day. With the current rate at which they're coming in. It's tough to tell when we'll get finished through all these testing. Now, keep in mind, all this testing is being done free of charge. As the customers are reaching out, asking us what we can do for them during this time. And obviously we're going to do what we can. And so these tests are monopolizing our time all day, every day right now.
Let's talk about, you said you had the capacity to do 80 to 85 a day. Why is that capacity limited? What is the limitation of that capacity?
That capacity is limited due to personnel and our equipment and instrumentation being able to handle those samples on a daily basis.
Because on the plates can only hold so many samples. And then we heard yesterday that some of the space on those plates is for the controls, right?
Correct. So getting samples prepped and on the incubators, and our first samples should come off and reported out later today, since we've been incubating since Monday. But those plates have 96 wells on them, and typically we run 4 controls, 2 negatives and 2 positives off those plates. So if we can get all the samples prepped, we could get up to 92, but with all the sample prep we're doing right now, we're averaging 80 to 85 a day.
And these hundreds and hundreds of samples are tests that Viridis has already performed and already passed under your validated methods, correct?
That is correct, sir.
So the only reason that you're redoing all of these is because of the recall, correct?
That is correct.
And one of the components of your damages is the lost capacity to do paying work in those incubators, right?
Yes, this is having probably the worst impact that we could imagine on our revenue generating samples, which obviously we're not seeing many of those at this point because of just the uncertainty of everything that's going on with this recall. So,
and you mentioned that a lot of customers are asking or demanding that you do this retest for free, right?
Yes, not only that, sir, but those that they are outsourcing to other laboratories to get retested. There's an expectation, they've been reaching back out to us, is how are you going to cover these costs that we're incurring from these other laboratories? And the best we can do at this point is to provide them some level of credit for future testing if they decide to come back with us.
So if I heard that correctly, you have customers that have come to get the test samples off of your shelves, send it to them, your competitor, and these customers want you to pay that bill because the MRA has accused you of having unreliable test results, right?
Yeah, in short, yes, some sort of reimbursement, yes.
Okay, and you've already received a number of letters from these customers threatening litigation, correct?
Correct. We currently have 3 letters on file that we've sent to our insurance companies here that are threatening litigation. Yes.
So let's just sum this up. And if the recall were to end today, if there was a ruling that the recall was never valid in the first place and never should have happened, how would life at Viridis Lansing and Viridis North change immediately?
Well, I think to get us back to doing really revenue generating work, first of all, we can put aside all these retests that are not generating revenue, and we can start seeing some of these revenues coming in again, because currently we're not seeing any cash collections either. The customers have stopped paying us, and we have several $100,000 in accounts receivable, and we've not seeing any of that come in except for just a little bit. In fact, we're having checks canceled that were sent to us, and so we're not receiving really any revenues at this point. The cancellation of the recall, obviously we would get back some of the loyal customers here, but to what extent is yet to be seen, Counselor.
But some of those customer relationships might be things that could be repaired potentially if this is ended soon, versus if you're ultimately vindicated 6 months from now, there's going to be lawsuits about who owes who for all of these tests that were done during this recall process, right?
That is correct, yes, sir.
Okay. And if this recall is not lifted, what is your prognosis for the viability of Viridis Lansing and Viridis North?
Oh, these two beautiful multi-million-dollar laboratories that we've built, we have about 2 months of operating expenses left. So it's highly likely that we'll have to close our doors, sir.
That's all I have.
Any cross-examination? All right. Thank you, Mr. Mashad. We appreciate your testimony. I hope you start feeling better.
Thank you, Your Honor.
All right, have a good afternoon.
You too.
Your Honor, can I ask, am I literally on the clock now, or if I'm going this fast, can I not worry about how long this is taking? I asked for 30 minutes and
I'm
if,
not keeping a clock,
okay, thank you.
but
I'm trying to keep it go as fast as I can.
I appreciate that.
Okay. We would next call Mr. Jonathan Kowek, Koweck. He should be in the Zoom room. I'm sorry, I looked at you.
Is it Kowack? Is that what you said?
Yes,
Oh, yep, Kowek.
How are you doing today, sir? Can you hear me?
I can hear you. Doing well.
Okay. Would you raise your right hand? You solemnly swear the testimony you provide in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Good afternoon, Mr. Kowek.
Good afternoon.
Can you please tell me what you do? What is your title?
I'm the Director of Supply Chain for Loom.
Can you speak up, please? The court reporter didn't hear that.
I am the Director of Supply Chain for Loom. Can you hear me?
You get that? Director of Supply Chain for Loom.
Boom.
Lume. Mr. Kowek, you're not here today to take sides between the MRA and Viridis, correct?
Correct.
Sir, can you put that microphone closer? It's very hard to hear you.
Yeah, let's see. How about now?
Yeah, that's better.
Okay, I just want to be really clear. You are not here today to take sides between Viridis and the MRA, correct?
Correct.
Do you know approximately how long Loom has used Viridis as a lab?
When they became licensed, it was probably early last year.
And generally speaking, is Loom happy with Viridis as a laboratory?
Yes,
But it is possible that what the MRA has accused Viridis of is true, and you don't have any personal knowledge of that, correct?
correct.
So you are here solely to talk about the effect on Loom of this recall, the ongoing
Correct.
effect, right?
Correct.
Okay, so I want to, could you just give us a very brief snippet of what you do as the supply chain manager and the size and scope of the Loom business?
Yeah, so I have everything from purchasing, logistics, some of the little bit of the design work. So seed to stump or seed to smoke basically is within my realm of control.
Yeah, it's
So
really quiet.
Is it? Yeah, it's a new microphone. So how about now? Is that better?
Yeah, she said if you could keep your voice up or maybe even just hold that microphone, the closer you get, the better.
All right, let me zoom in a little bit. Here we go. How about now?
Better, thank you.
Okay, you're welcome.
Okay, can you just describe again what you do as the supply chain manager? She didn't get all your last answer.
Oh, yeah, it's essentially controlling all supply for the organization, both inbound and outbound materials, finished goods, as well as raw materials.
Round numbers, how many plants does Loom grow statewide?
Right now, yeah, so we've hit 250,000 square feet of indoor grow space. We're harvesting about 600 pounds a week.
And how many stores does Loom have? Open stores right now?
As of today, we have 27 open. One is just pending, so it should be opening next week. And then we have 4 under construction, along with several properties already purchased and waiting for construction.
How much supply do you have in the supply chain that is being affected by the recall right now?
So right after the announcement came out on
Hold on a second, sir. I think there's an objection. So what about the harm to the public? Okay. Overruled then.
Your Honor. I'm sorry, how many, can you quantify the amount of material that is currently held up in the supply chain due to this recall?
Currently, we have about 125,000 units, which is about $2.5 million in retail value.
$2.5 million in product that's currently tied up in the supply chain?
Correct.
And that is distributed among your 27 stores?
Correct. Plus cultivation.
Okay, and how many packets or samples need to be retested to free up that $2.5 million worth of product?
I still have about 650 pending.
There are 650 pending retests of material that's tied up in the supply chain due to this recall?
Correct.
And how many SKUs does this affect?
It's about
Ballpark.
How
500.
many what?
SKUs, individual products,
Yeah, it's about 500.
500. And everything that is currently under the recall, all the material you were just talking about was tested and approved before the recall went into effect, correct?
Correct.
So it has already been tested and approved, was at some point in the supply chain on the shelves or on the way to shelves, and $2.5 million worth of product is now locked up because of the recall.
Correct.
But I have a question.
Yes.
And maybe it's a point of clarification. You can answer. I don't know. He testified that to your question that it was tested and approved prior to the recall.
Correct.
Okay, so it was not, so the material that he's dealing with, or part of it maybe, I don't know, was tested prior to August 10th?
No, excuse me, not, yeah, thank you for helping me clarify that. This is material that was tested between August 10th and November 16th.
No,
It
it
was
tested favorably,
correct,
but because of the recall and the questioning of the methods, it has to get retested.
correct.
Right, okay, good.
And as of now, how many of the retests have come back?
Approximately 80.
Approximately 80. And what were the results of those 80?
We all have passed so far.
I'm sorry, I'm not hearing you anymore.
All have passed
100% of your retests have passed?
as of today. Yes.
Let's talk about what you did, kind of a timeline. The day you found out, the day the recall was issued on the 17th, how did that affect Loom on day one?
So day one, once the recall came out, we had the dates and with 27 locations and not able to just, click a button, and MRA was still going through putting on holds on the products. We quarantined all affected or suspected products that were affected by the date range and those testing labs. That was about 200,000 units went into quarantine immediately.
Okay, and was anything destroyed immediately?
Displays. So anything that was displayed already that was a part of the recall was destroyed, which was about $80,000 worth of product.
$80,000 worth of product you destroyed immediately based on the recall that's at issue in this case.
Correct.
And I want to, before we move on, all of the product we're talking about, the $2.5 million of product that we're talking about, was that tested originally at Viridis Lansing or Viridis Bay City?
I would have to get clarification, but mostly Bay City was the lab that we typically went to, but it was always up to Viridis which lab the sample went to.
Okay, but your understanding is the vast majority of it was at Bay City?
Correct.
Okay, so if Bay City was carved out of the recall, you would have millions of dollars worth of product freed up, millions of product that it was already tested and approved, but it's subject to this retesting because of the recall, right?
Correct.
Okay. So on day two or day one, whenever, how did you go about implementing a plan to start the retests?
So immediately contacted other labs and partners willing to go into Viridis to pick up those samples. We also had weight at cultivation that was already at retail and additional tests that hadn't been tested yet. So we phased it in quite quickly. So we started testing product that was already at cultivation first, because that was the easiest win. So we got those results back, which started trickling, releasing product as we went. So every day, as additional test results would come in, then we would get with our teams, go into each instance of metric, and then release those packages as we were getting the admin hold released.
So the stuff that was already at Viridis, you had sent to competitor labs, correct?
Correct. The following week.
I'm sorry?
The following week.
The following week. So
Yeah.
you came and picked up, or excuse me, the competitor lab has to physically come get it from Viridis, correct?
Correct.
Came and got it from Viridis Bay City and went and did their retests. And what are some of these competitors saying about the approximate time they expect these retests to take?
Some were very fast, but now we're coming in. They're all talking about supply chain issues and the consumables used to conduct the tests. They're running out of supplies. So it's indefinite as of today. I don't have specific dates for any of the additional tests that we require.
And when you say supply chain issues, you're referring to kind of COVID supply chain issues with the plating and the pipettes, things like that?
Correct.
So Viridis's competitors don't have the materials on hand and expect delays getting the materials to cover this overflow, correct?
Correct. That is my understanding.
How much will the recall cost if the injunction is not issued?
It's all based on the test costs. So I would have to do some math, but it's anywhere from $100 to $300 per retest.
100 to 300 per retest, and you said there's 600 some retests?
To go, yeah.
Okay, that's all I have. Thank you, Aaron.
Cross-examination.
You have an interest in making sure that your product is safe when it goes out for sale, correct?
That is our number one priority.
And would you agree that safety of product, whether it be medical or for adult use, that goes out into the public for consumption, ultimately is more important than an individual company's finances or pocketbook?
Agree.
All right, thank you.
Redirect. All right, thank you, sir, for your testimony. We appreciate your time, and have a good afternoon.
Thank you. You too.
Is there a Craig Flocken in the Zoom waiting room?
Jeff, is there somebody else in the waiting room?
Judge Murray, there's nobody in the waiting room right now.
All right, may I have a 2-minute break to call him and try to get him on as soon as possible? I just spoke with him and he said he would be 1 minute. So
Who is it?
it was Craig Flocken, Flocken. With Evolution Grow. The name? Ocken. Craig, yes, Craig. Sorry for the delay, Your Honor. This was poor planning on my part that I was up at the lectern and couldn't be texting the next guy to be ready, and we should have delegated responsibilities differently.
Good afternoon.
Good afternoon.
You're Mr. Flocken?
Yes, sir.
Okay, do you have a microphone there or anything? You're still a little quiet.
Just a second, sir. Hold on.
I don't know, maybe it's on our side. But the first witness, she was fine. Yeah,
Can you hear me now, sir?
a little bit. I mean, we can hear you. Yeah, it's just, you're gonna have to make sure you speak up when you give your answers, okay?
Okay.
All right, would you raise your right hand? You solemnly swear and affirm that the testimony you will provide in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Good afternoon, Mr. Flocken. Could you please state your name for the record?
Craig Flocken, F as in Frank, Locken.
And where do you work, Mr. Flocken?
I am work for Evolution Grow Company. I'm the president.
You are not here today to take sides between Viridis and the MRA, correct?
Correct.
Do you know how long you have been using Viridis as your safety lab?
Since beginning of July, I believe, this
Okay.
summer.
Is it fair to say you're generally happy with using Viridis as a lab?
Yes,
But it is possible that the MRA's allegations against Viridis are correct, and you don't have any personal knowledge of that, correct?
I do not know.
Okay. We're going to ask you today about how this recall is affecting your business. Can
Okay.
you just in a nutshell, could you explain how this recall has affected you both over the last 2 weeks and even today?
So the recall has affected our business. We are Class B grow operation here in Battle Creek. And on the 15th of November, which was a Monday, we had scheduled Viridis to come to our facility to collect samples for our most recent harvest. We are an indoor grow hydroponics, and we only have one harvest a month. So on the 15th, we had scheduled Viridis to come into the facility, collect samples so that we could get our latest harvest out to market. That was 171 pounds worth. And then on Wednesday, the MRA obviously sent out their notice of a recall for anything tested by Viridis, which stopped our in-progress testing. So we never got a result back from that.
Okay, Mr. Flocken, I'm sorry, I don't mean to interrupt, but
Yep.
if I could ask you to focus on the materials that were already out in the market, please, not the things that were on the way to testing. How has this affected your business relative to the products that were already on the shelves or on their way to the shelves?
Okay. Same week, we had a deal for 68 pounds of our flour to be purchased by a large dispensary company going through another processing company. The recall happened the day after that 68 pounds was collected and stopped the sale dead in its tracks. That sale still has not been able to be fulfilled 2 weeks later because the flour is on hold by the MRA. The other items that we are having to deal with include dispensaries that have our product that were shipped to their dispensaries but tested by Viridis between August and the November 16th date. We have been having to work with the customers on the dispensary side who, based upon the MRA guidance bulletins, have been asking us to test product that they've already had out in their dispensaries. So unfortunately, go ahead.
I was just going to say, so the MRA, the provisioning centers are calling you and saying that the MRA's guidance says that this needs to be retested, right?
Correct, because the items that we sold them were tested by Viridis, therefore all the product is on hold. They can't sell it.
And do your customers want you to pay for that?
Well, the guidance from the MRA bulletin was that either they could have testing companies come out to their facilities and test at the dispensaries for the microbials, or they could send the product back to our company to test. As a
grower, right?
Correct, the grower. So the problem with that for us is that the cost of the tests, number one, and number two is that this product, a lot of the product has already been opened by the customer. So, and it creates an issue for us because if a test is done by the customer on product that's already been opened, they're trying to say to us that we're responsible for any failed results and any testing, but it's difficult for me as a business owner to say, or for them in the matter to say, why is it, if it fails, why would it fail? Was it us or them? So,
right. So I want to clarify something you said. You said the customer has already opened it, but in that sentence, you were talking about your customer being a store, not the end user, correct?
Correct. We sell our product in 1 pound bags. So a dispensary, for instance, would order 10 pounds or 5 pounds from us. We'll say it's just an average order, 5 pounds. They will open the bags, break all the pounds down into the amounts that they sell to their consumers. And so it's split up. The bag's been opened, been touched, been handled, been repackaged. And as part of this recall, the dispensaries are saying who's going to get this tested. The guidance says they can test it. And so the dispensaries are telling us, well, you know, the cost of the tests are 200 or so, give or take. And every item's got to be tested.
So one component is just the sheer cost of the test that you're caught in the middle, right? Your customers are expecting you to pay for that because you are the grower, right?
Correct.
Okay, and another problem with that is that your customer, a store, has taken these 1 pound bags that have passed testing using validated methods and broken them into a bunch of little bags, right?
Correct. For instance, we had a company last week that had 24 pounds of our product in their store that was on hold. Out of that 24 pounds, 6 pounds were on unopened bags, which is not a problem. Unopened bags, hey, that's great. Get the testing company out there, test those 6 bags, or send them back to us and we'll test them. The problem is, under the MRA guidelines or the guidance, all 24 have to be tested for it to be freed. And so we have.
Can I interrupt you, Mr. Flanagan? We still
Yes.
hear you, but we don't see you
No.
on our screen.
I don't need to see him.
Okay,
I know what he looks like.
all right, never mind, keep going.
All right, so the 18 pounds is what the problem is because that's been handled.
Okay, so I imagine you've had lots of conversations and calls with your customers' stores in the last couple of weeks. Can you quantify roughly how much of your time has been spent doing that?
So I would say probably about 40–50% of my days are trying to work around what's going on. I will tell you that our sales have dropped to pretty much nothing over the past 2 weeks. We are just starting to get some traction with our gummy line. But part of the problem that we've been dealing with is our sales teams have been calling companies to at least get gummy products sold. And the response has been from nearly all the dispensaries over the past week and a half, 2 weeks, is that they are too busy trying to navigate the recall product to order from us gummies. They have to get that sorted out. So that's kind of affected us in the sense that we can't even get gummies, which are not even part of the recall, out to market.
So you're one of the ways that this is affecting your day-to-day business and interfering with your business is you said you spend half of your day talking to angry customers that want you to pay for the retesting, right?
Not to angry customers. I would say more trying to navigate and get our customers to one, understand, what we can do or what they need to do. And then at the other side is trying to talk to other purchasing partners, dispensaries, to try to get them to purchase product. That's
Right.
that is not flour on hold.
Right, and that was the second point I was going to get to. So what is your sales team staff at your company?
We have 3 salespeople full-time.
And so their full-time job is to try to make sales. And you said you made no sales between the 17th and the 29th of November?
Yesterday was our first sale where we had we had a couple small orders where the companies that we talked to were able to, they apparently had navigated their issues enough so that they could place some orders.
And are you concerned at all about the reputational risk that these samples that were tested under validated methods and passed in the 1 pound bags were then at a store and broken into other bags? If those come back as a retest fail, doesn't that reflect on you as the grower that somebody might suspect that was adulterated product from the beginning?
Well, yes, that's always a concern. And that's what we've been trying to explain to those customers that have called us, is that we shouldn't be accepting the responsibility for a failed product test on something that's been opened or broken down. We don't know what their conditions are like in the store, what precautions or environmental concerns in regards to contamination have they taken. The unopened bags, not a problem, but we're having to deal with stuff back from August. Nearly everything's been open since August.
Right, you said that one store alone, you've talked to several stores, and one store alone had 20 some pounds that they wanted you to cover the cost of retesting?
Yes.
That's all I have, Your Honor.
Cross-examination.
You agree that you have an interest in making sure that your product is safe when it goes out on the market, right?
Yes, ma'am.
And would you agree that providing safe medical and adult use marijuana to consumers in the public is more important than any company's finances or hurdles they may have to jump through to make sure that safe product is put out on the market?
Yes, safety is a priority, yes.
More important than any one company's finances?
Yeah, safety for the consumer absolutely is, yes.
All right, thank you.
Mr. Flocken, I have a question.
Yes, sir.
Are you aware that the MRA has has allowed, for lack of a better word, to have Viridis in full operation now?
I am aware of it, yes. I did receive a notice from Viridis stating such.
Okay, good. And are you going to continue using them?
We like them. They've always been good in the sense that they've always been professional and timely. So for us as a company using them, I've never had a problem with their professionalism or service, no. So yes, I would continue to use them.
Thank you.
Ask one question on the redirect, please, Mayor.
Sure.
There was some, Mr. Flocken, there was questions about the health and safety of customers. When 65,000 pounds of material is all automatically locked down, is the illicit market marijuana tested for any of these chemicals, pesticides, aspergillus, any of that?
Could you repeat that?
So if all of the legal licensed marijuana all of a sudden becomes locked up and nobody can buy it anymore.
Is this a hypothetical? I mean, this doesn't cover all the legal marijuana. Your clients don't have 100% of the
Correct.
market, do they?
Correct.
Okay.
So if a good percentage of the legal licensed tested marijuana all of a sudden was unavailable and consumers were forced to use marijuana from the illicit market, is the marijuana on the illicit market tested for any of the chemicals and aspergillus and pesticides and heavy metals and total yeast and mold, any of that?
No.
Thank you.
All right, Mr. Flocken, thank you very much for your time. We appreciate it. And I hope you have a good afternoon.
Thank you, sir. Have a good day.
Yep, you too. Okay, any other witnesses?
Oh, Your Honor.
All right. I have it's 12:45, 12:46. We're gonna go till 1 o'clock, so you each get about 5 minutes. So I'm gonna have you on the clock, so to speak, for these. Okay. So Lance, you can proceed. It's your motion.
Your Honor. One, I would just like to thank the court for its time and reiterate the points in the amicus brief and the testimony that came out today on rebuttal. The response brief that suggests this recall is over is absurd. It is literally just starting. It has already caused irreparable harm, and every day that it goes on is causing irreparable harm. It is not hyperbole to say that this is the biggest thing that ever happened to this market and this industry in the history of legal marijuana in the state. And it is one of, if not the biggest recalls in the country on the flimsiest of reasons. There was some discussion yesterday about, a TRO or a preliminary injunction. What are we asking you to enjoin the court to do? I admit that when you think of it in terms of we're enjoining a recall, that doesn't sound good, right? But I want to stress to the court that that is the procedural mechanism to get a quick decision, right? When there is irreparable harm, and
I don't doubt that. I think I've made my point, my question, my concern is clear. You're asking the courts, a separate branch of government, to step in and stop a fact-based, whether it's flimsy or not, a fact-based decision. This is not, I mean, I know you, and the legal arguments, I already know what they are, okay? But this hearing is focused on the facts, to some extent. I mean, I understand the whole thing about the vagueness of your argument about the vagueness of what's been being done, and the lack of notice, I guess, in a way. But most of the cases, and correct me if I'm wrong, but the vast majority of cases where a court enjoins a agency, it's because the court concludes that they didn't follow the APA or what have you. It's more of a legal side determination, and usually, in all honesty, the other factors in the preliminary injunction are almost throwaways. This case is totally different in my view. I mean, unless you accept, and I'm not saying I don't, but the legal arguments that we already know about. But it's a great concern to me to step in to the agency that has been delegated the responsibility to handle these things and is given the power to do a recall, to then say, I don't agree that you have sufficient basis to do so, so stop. That is, in my view, a big step to take for the judicial branch. So tell me why I'm wrong.
Your Honor, I respectfully disagree because with this case is about the legal issues. I think that the last 2 days have focused on facts because the state, or excuse me, the defendants chose to not address any of the legal issues and instead talked about standing and exhaustion and typos in their brief and scare tactics that Your Honor is going to be hurting people if they let this stuff off the shelves, and glossing over the fact that these labs have been tested and retested and passed all the proficiency tests. And again, this isn't a situation where there's no trust in the lab. That's essentially what they're saying, though. They're saying you can do it when you're being watched for the proficiency tests, but when we're not looking, we don't trust you to leave it in the incubator long enough because you don't have the log to prove it. And so we are asking for the legal argument that this was ultra vires. The rule that contemplates recalls does not mention notice, but it needs to be read in harmony with all the rules and all of the APA provisions that do require notice. And all of those consistently.
They did give your client some notice. I mean, the testimony was, here's a copy of the recall notice that we're going to issue, let us know what you think.
Right, and the exhibit I believe, to the complaint ends with that, where we gave our feedback and said, there's alarmist stuff in here. If we disagree with the factual basis for this, but if you're going to do it, you can do it and accomplish the same thing without this alarmist rhetoric. And none of those suggestions were taken. And we didn't get notice of the reasons for the recall, never written. I mean, that was, Ms. Patterson admitted, I think in response to your question, there was not a written notice ever of that. And the Iron Labs didn't come in. I understand this is a preliminary injunction hearing, but we wanted to show that as this is what has happened. This is what should have happened. And all of those rules and all of the APA provisions do require notice, except in extraordinary circumstances where it's so dire that they have to do a suspension of license.
But what do you, I mean, a recall, one could argue, whether you're dealing with marijuana or beef or whatever it is the whole idea of a recall is to protect the public, right?
But is that enough to just wrap yourself in that's my point.
I am right, though, that a recall is to protect the public. Correct?
Ostensibly, yes.
As a general proposition,
yes,
that is the case. Is there any other statute in Michigan that, whether it's with the agricultural department or whoever, that says you need to provide the following notice before you do a recall?
yes,
Okay.
I don't have those memorized, but I do know in the agricultural context, there are specific procedures of how to do it, how to give notice. And there are even, restrictions on what the licensee can say in the middle of a recall, because that could affect public health. So we're not talking about asking the court to rule that the MRA needs to flesh all these out in a rule before this happens. We're not asking the court to say that a recall can never happen in a dire circumstance. We are saying in this circumstance, there was no notice, they violated the APA, and if we are vindicated 6 months from now, that's not going to do any good. There is going to be millions and millions of dollars of damages incurred between now and then, and Viridis will not survive this if we have to wait 6 months to be vindicated at the end. And that is what the injunction is, the procedural mechanism that we show a likelihood of success and irreparable harm and the other two elements, and the court can step in and say, this was ultra vires. This should be, and that's not stopping them from doing a recall tomorrow if they do it the right way, right? We're not saying they can't do it if they have a cause for concern, but
But when you say you do it the right way, are you talking about notice, opportunity to respond? I mean, again, one of your points was that they didn't act as soon as they should have if it was such a dire situation.
right, they waited 3 weeks.
Right, I understand.
Okay.
But that begs the question: is there a statutory requirement or a due process requirement to? I guess my point is that what type of notices should be provided to an affected industry before a recall depends on the circumstances, right?
I agree. I agree with that.
So the fact that there's no administrative rule on outlining specific procedures to follow in the event the agency is considering a recall may not be a deficiency.
Your Honor, I agree. And we're not asking you to rule that there needs to be rules outlining exactly when a recall might be triggered or not triggered, or how would it be implemented. I think that's a good idea. The MRIs existed for 2 years and they don't have a process to govern recalls, when it's going to happen, how it's going to happen. And prospectively, that's a good idea for them to be thinking about that and doing that. But we're not asking the court to say that these recalls can never happen, because if there is a safety issue tomorrow.
No, I agree. But then what is the legal defect then?
No notice. There was zero notice of this.
That's what I said is, what am I supposed to look at to say the law requires that the agency should have given notice under these circumstances when it varies situation to situation?
There are statutory provisions and rules that specifically require notice, and
Prior to a recall?
prior to any act that would restrict a license or suspend a license or.
Because the restricting and suspending and the de facto stuff is different than the recall.
The recall itself, I don't want to confuse the two things, right? So we're only going to talk about the recall today, not the post-recall de facto suspension. The recall itself is a restriction on the license. Under the rules, a licensed lab can test and release product. When they do a recall, they are reversing that course and making all of the product that's already out on the shelves come back and be tested again.
Right.
So that is a restriction on the license, and there are several rules that are clear, the MRI's own rules, that they should have given notice of that. And I agree with you that I'm not asking you to say that it has to be 48 hours and you have to have a notice, whatever. I'm saying in this specific context of this case, there was not notice and there should have been notice. There was testimony today where the MRA's representative admitted that the aspergillus was the basis for the recall. Aspergillus and the retest that went out to competitors was aspergillus and potency. Potency is a red herring. It preceded all of the issues in this
That's
case.
what the administrative issue is about, right?
Correct. So it was aspergillus and potency. For aspergillus, she admitted on the stand that the aspergillus temperature, the temperature of the incubator was correct. There was no deviation there. The sole deviation that she called a deviation was there wasn't a log. And again, they said that the log itself would not have justified this, but they did it anyway. 65,000 pounds.
So then how do you and it's probably in your brief and I'll look back at it afternoon, but how do you, is that just, so it's therefore an arbitrary agency decision that should be in light of the other factors under the should be enjoined?
Absolutely. Should be
Okay.
enjoined, or it's ultra vires. It's void from inception. So that again gets
Ultra-virus, doesn't it, ultra-virus, I can't remember, doesn't that mean just an unlawful?
they without authority
But they
an
do have
agency-
authority to do a recall.
if they follow their procedures. Your Honor, I think all of that has to be read in
How many
harmony.
procedures?
The APA and the regular procedures about restricting a license do require notice. You have to read those together. The one rule that talks about a recall does not say anything about notice. But you don't read that in a vacuum. You read it in combination with all the other rules that require notice before any restrictions are placed. And again, we have 2 weeks of emails where we were specifically asking them to follow those procedures, and they didn't. And they sat on the information for 3 weeks. Again, the recall was as to aspergillus only, and the only witness from defendants has admitted that there was no deviations on that related to aspergillus at all, except the absence of logs, which was not a requirement under the statute, the rules, anything. And so we are simply asking, and again, none of the retesting had anything to do with Viridis North. And the crippling effect this has had on the industry. And we're not asking the court to step in and second guess the science or any of that. We have alluded to that, and we've spent some time on that, only to rebut the scare tactics, the conclusory scare tactics in the brief. And I think that speaks volumes that they didn't address the substance one iota in their brief.
Okay, all right,
Thank you, Your Honor.
thank you very much.
Your Honor, a recall is not a restriction or a suspension on a license. It's a mechanism to protect the public from potentially contaminated or harmful products. Viridis's licenses are full licenses, that there's no restrictions or suspensions placed on them whatsoever.
But there, I mean, factually, there was some evidence about which I guess they're not maybe arguing as much now about the de facto suspension, because I mean, there's clearly emails that said, you know, you got to do this or that before we give you the okay to move forward.
I respectfully disagree that that constitutes any kind of restriction or suspension, but that is a separate issue than the recall. Recall is not a restriction or suspension. It's a mechanism to protect the public. And the,
Can I ask you a question about the recall though?
yes,
I mean, it sounds like from it's been somewhat limited, but some of the testimony is that the retesting that's being done so far has been positive.
you mean passing or failing?
I mean, like the passing, like in the good sense.
The testimony today was that 27% of the product that has been retested.
Oh, that was from Ms. Patterson, but
Yes.
the gentleman that just testified, or one of them, I thought he said that so far they've had, I thought he said 100%, but maybe I'm wrong.
Yeah, and perhaps the products that he grew.
Well,
all
but
have-
anyway, my question still goes, so if she said, did she say 83% was positive and 27% was negative?
She said that 27% failed, so.
Is there a point in time where the agency will be continuing to monitor these numbers and make a determination that, you know what, we feel good about it and we're discontinuing the recall? Or are they gonna have to retest everything possible to get through all of this?
No, I don't exactly know the entire answer to that, but 27% is considered a high fail or a high failure percentage. And so in order to protect consumers, we don't want, especially medical patients, so also those who have the lung conditions or compromised, we don't want them to have that product. So if this court enjoined the MRA's ability to enforce this recall, there would be tons of product that had been recalled that wouldn't be retested. It would just go out back to the market in whichever way.
Right.
But we already know that there's 27% of that product that's been dirty.
What about Bay City? I mean, the testimony that I recall is that these samples did not come from Bay City.
That's true. They all came from Lansing. And that was, you heard that was done randomly,
Right.
but the Bay and Lansing labs have identical SOPs, identical testing methods. And so although none of the retests came from Bay, there are still those deficiency or non-conformancies with the testing method.
Yeah, but for an agency to issue a recall against a lab that they haven't even tested their product, to even have any idea that there's an actual problem, I mean, that seems,
Well, there, you know, we did observe problems, or the MRA did observe problems through July through September. There was no logs whatsoever. So if no one knows how long those products or samples incubated.
I
for
get
or
that,
after.
but my point is that you do a test, which seems prudent, to make, you know, when you have you see a problem, you go and get some of the product and test it to see if the problem is resulting in, you know, deficient product being released or approved. And it's all from one lab, and you say, yep, there's a problem. And then you say, by the way, you up there, you can't do it either.
But they have the same owners, the same procedures, the same methodologies, the same.
Yeah, but
performances.
wouldn't I mean, a recall is a big deal. We've heard the impact it has on businesses. And I'm sure there's countless more that could have come in and testified. Yet you don't take the extra effort to test to make sure it's the same problem up in Bay City.
I don't think it was like the choice to not make the effort. It was a random sample. They were trying to clear.
Yeah, but did they know they were from Lansing before they issued the recall?
Yes,
Okay, well then the same holds true then.
but let me reiterate that 27% of the tested product is failing. And so some of that has come from Bay.
How do we know that? Has there been testimony about
No,
that?
there has not.
Okay. All right, well, anyway, those were the questions. You can argue what you want.
I just wanted to reiterate that if the MRA is enjoined from enforcing this recall, we're going to have loads of untested product that the MRA, who's in charge of regulating the safety of marijuana in Michigan, has determined presents a risk to the public. And so it's just that risk to the public, and we know that it's testing dirty, outweighs anything else. And the MRA's in charge of it. They have determined that this is necessary. And they've acted to protect the public. As far as irreparable harm, we heard a lot of testimony or some testimony today about economic damage, but you know, I know you know what the law provides that loss of income and other monetary damages doesn't constitute irreparable injury. And we also heard that the last person there would continue to work with Viridis. You know, it sounds like it's a nuisance, to say the least, for these businesses to deal with, but
Or in the nuisance.
yes, it's a bad choice of words, but it's not never repairable. As far as the balance of harm weighing against the issuance of an injunction, you know, the court itself has alluded or outright said that the agency, the regulatory agency, has to be able to do its job without aggrieved business owners or persons regulated by the state running to court every time that a recall is issued, saying enjoying, and being subject to a 2-day hearing. They are in charge of regulating marijuana, the safety of marijuana in Michigan. They enjoying them from doing that is just, it outweighs the benefits to the plaintiffs. So unless the court has any other questions,
No, I do not. Thank you.
thank you very much.
Your Honor, may I have 30 seconds, please? Last word, it's our motion.
Sure. You want me to test it 30 seconds?
Yes, please. Yes, please.
I'm just
I'm-
kidding.
Okay. Your Honor, I think there was testimony today from the supply chain manager of Loom. $2.5 million of product that's locked up right now, and 100% of his tests have come back, retests have come back positive, okay, right? So, and he talked about on day one, day two, you know, within a couple of days, they had to destroy $80,000 worth of product.
Look,
And my point, I'm sorry, was coming from Bay City, and Bay City was never tested. That's my point. Everybody that's stuck in the middle here, at the very minimum, the court can carve out Bay City and say, that
Do they, isn't there a way that, whether it's on a label or, well, I guess it would probably be labeled, is it trackable or traceable to?
Yes.
Yeah, to say
Yeah,
where
so
it comes from.
if the court
Right.
carved out Bay City,
Right.
millions of dollars of product would come out from under the recall immediately. And again, the MRA could do it again, but do it the right way. And we would be before an ALJ and arguing about the science and whether it was supported. And I think as a court of law, this court has a responsibility to hold agencies accountable and make sure that they are not overstepping their bounds. They do not have the power to issue these without notice. And we're not saying in a
Right.
absolute sense, but in this case, there was not sufficient notice.
It's hard. Overstepping the bounds is usually they go outside their delegated authority. And this is not outside their authority. The problem is, your argument is that that they don't really have the process in place to give notice, and there really wasn't a sufficient justification for what they did because of the aspergillus and the log issue.
That's part of it, Your Honor, but I'm saying they did act outside their authority respectfully, because their authority allows them to do this if they follow the APA, and they did not. There's no question about that. We're not saying an absolute.
But there's no question about that. The question is whether the APA governs on the recall, but I'll look at that. I'll look
It's
at
cited
it.
in our brief that the
Yeah,
statute
I'll-
specifically incorporates the APA. Thank you.
Right, but for rulemaking, right?
No,
For
for,
everything?
yeah, I don't have it memorized.
I'll look at it. I'm sure
Okay.
you've got it in there.
Thank you. Your Honor.
Thank you all for your time, your arguments. Hopefully I haven't been too impatient with you, but I always tell people my real job is the Court of Appeals, not the Court of Claims, but I'm doing the Court of Claims and not for long though. So anyway, thank you, and I will get a decision out to you, I hope by the end of today. But I've got a lot to think about, and if not, it certainly will be before tomorrow, the end of tomorrow, but as soon as this week, I won't make any other promises.
Thank you.
But trust me, the only thing I'll be working on is this case, so don't worry about that.